Well, good morning, everybody. Thank you for joining me today for this session on Underinsurance and the Insurance Act 2015. A quick word about me before we get on to some housekeeping. I'm Alex Rosenfield. I'm a partner. I tend to specialise in anything that has a property damage flavour, and underinsurance has been a particular hot topic and is always something that brokers are keen to discuss with me when I have conversations with them about this. A couple of housekeeping points very quickly. This session is recorded and the slides and the recording will be available to you tomorrow. You will also receive a feedback form, so please do offer your feedback when you get that. And as we are always keen to improve and make some marginal gains with our delivery. I'll talk in this session about what underinsurance is, why it's such a problem for policyholders and brokers too, and I'll talk about the different remedies that insurers look to where there is underinsurance, and also the interplay between them. And finally, I'll wrap up with a discussion about a case that I know will be familiar to many of you, which was in the legal news probably a couple of years ago now, called Infinity Reliance and Heath Crawford, which I think is a very useful case study on traps to avoid, and of course was a particularly sobering lesson for that broker involved. This is a topic that's a bit of a minefield, and there is, as I understand, very limited and perhaps no post-Insurance Act case law at all that deals specifically with underinsurance. So some of the principles I'll be talking about are untested, and I'll be offering my views on where I think the direction of travel will be. There will be there'll be a question and answer box that you can access, but I'm going to ask you kindly to leave your Q&As, or leave your Qs to the end, and then I'll provide the answers as far as I can. Check my clicker's working. Indeed it is. So let's start. Oh, apologies. Let's start with a bit of a quiz. I'm going to ask you, well, you can see the question on your slide, and I'd like you to, once I get this going, tell me what you think the answer is. I see a lot of you are very keen, so thank you for participating. I'll give you a minute or so, and then I'll tell you what the answer is. Okay, I think you've all, well, I think, oh no, some answers are still coming through. I'll give it a few more seconds. Okay, I'm going to end the poll and I'm going to share with you the answers, or the results rather. So those of you who selected 75 to 100% are correct. The answer is 76%, which I am reliably informed is an improvement from 81% in 2023. But isn't quite at the all-time peak of 83%. To my mind, that seems like a staggeringly high figure, and I think that is a very, very clear message that underinsurance is a serious and endemic problem, as I will now go on to talk about. So what is it? Well, I know this may be obvious, but as the name suggests, underinsurance occurs where the amount of coverage on a property, be it a home or a commercial building, is insufficient to cover the full cost of rebuilding or repairing if it's damaged or destroyed. It can happen for a number of reasons, and it is a strikingly easy trap to walk into. And just to give you a few examples of how it happens, I think the most obvious reason for underinsurance is just a misunderstanding of the sums insured. So people and businesses not including or factoring in all the necessary costs, such as demolition, debris removal, and architect's fees. And also, as far as contents are concerned, relying on the price of things years ago rather than current replacement costs. Another is inflation, so failing to take into account increases in labour, materials, or specialist equipment prices. And that's certainly been a huge factor in recent years due to a spike in construction costs. It can also be something as simple as not including VAT, and businesses that can't reclaim VAT often fail to add it to the sum insured, which leads to an automatic shortfall. And finally, and I think perhaps most importantly, trying to save on premiums. So I'll talk about this in a little more detail shortly. But if you deliberately underinsure to try and cost cut, that is a huge roll of the dice that can lead to a very severe punishment indeed. The implications of being underinsured can be very serious. Firstly, insurers tend to apply average, and I'll talk about that in a little bit more detail shortly. Secondly, the policyholder will be significantly out of pocket because they're going to have to fund the difference between what the insurance pays and what it may cost to fix or put right a building from their own pockets. And that can be disastrous if you're for very large claims, but even partial losses can still leave policyholders undercompensated. In the cases of serious underinsurance, or where the failure to disclose the true sum insured was deliberate or reckless, the insurer may refuse to pay the claim, but also avoid the policy altogether. And that would, to my mind, be the sort of thing that you would probably have to tell an insurer about in the future, because that goes towards your moral hazard and your character and your propensity to suffer a loss of a particular kind. And another corollary of all of that is that it might make insurance significantly harder to purchase in the future, and it may even make it hard to buy altogether. And there may indeed also be some commercial side effects of all of this. So, for example, it could frustrate business continuity, in some cases put directors in breach of their statutory duties, and also affect loans, that sort of thing. So I don't think it's an exaggeration to say that if you do insure a property for less than its true value, you can be left in financial turmoil in the event of a major or even a medium-sized loss. So average is the first of the two remedies that I'll talk about. So these are a staple of property and business policies. In a nutshell, the effect of average is to proportionately reduce a claim in relation to the amount of the underinsurance. And the rationale is that the insurer is deemed to have been put at a disadvantage because they haven't been paid the true premium to cover the full value of the risk. And so the policyholder is effectively its own insurer for the amount of the underinsurance. The intention of these clauses is really very simple. They are there to discourage and disincentivize policyholders for insuring at levels that are artificially low, and also to still expect 100% payout following a loss. The way that they work is set out in the somewhat crude but on point formula that you can see on your slide. So just to use a very basic example here, imagine a warehouse is insured for £1 million, but its true value is actually £2 million. In that situation, the policyholder is underinsured by 50%. And let's say it then has a major fire and there's an £800,000 loss. On our facts, the policyholder would only recover £400,000. And you can see straight away even from that basic example, how this could be very damaging to a small or a medium-sized business that doesn't have deep pockets. The next type of remedy that I'll talk about is a remedy for a breach of the duty of fair presentation under the Insurance Act. So under the Insurance Act, a fair presentation of the risk is one where the policyholder discloses every material circumstance which it knows or ought to know, or failing that, gives disclosure of sufficient information to put a prudent insurer on notice to make inquiries. And that latter aspect of the test has often been referred to as the signposting provision, whereby the insurer is given signposts to ask further questions, which would then reveal further material facts. The second aspect of the test is that every material representation of fact has to be substantially correct, and every representation of belief or expectation needs to be made in good faith, or put differently, honestly. And the final aspect, this sort of the good faith test, is essentially a statutory codification of a very well-known case on underinsurance called Economides and Commercial Assurance Company, which was all about a policyholder that underinsured his parents' jewellery, but the Court of Appeal ultimately found in his favour because it decided that his estimate of what the jewellery was worth was made entirely in good faith. So what are the remedies that insurers can apply when you breach your duty of fair presentation? Well, there are different remedies depending on whether the breach was deliberate or reckless, or just negligent or careless. So if your breach is deliberate, so let's say you deliberately provide inaccurate information about the sums insured in the hope of paying a cheaper premium, I'm sure you won't need me to tell you that that's a very serious breach of the duty of fair presentation indeed. And in that situation, the insurer will be entitled to avoid the policy altogether. So treat it as though it's never existed, of course, as well as refusing to pay the claims and keeping the premium. Whether a breach is reckless is a slightly more fiddly concept, and the Insurance Act doesn't give any specific or precise definition, but it essentially requires the policyholder to be indifferent or not care about whether what it's disclosing is true or not. So that deals with the situation where the policyholder doesn't care, but there is a subtle but important distinction where the policyholder doesn't take sufficient care. So if the underinsurance arises because you've negligently failed to present the correct value of the insured property, so you've entirely innocently just got the number wrong because you didn't take enough care, the insurer's remedy in that situation turns on what it would have done differently had the true number been disclosed. The Insurance Act provides for a number of proportionate remedies, but in this particular context, I think there's only two that are relevant. So the first is it can proportionately reduce the claim. So the Act does give a precise formula for how an insurer does this, but in a nutshell, if let's say the premium paid had been 50% of the true premium, had the true valuation been provided, then the insured, or the policyholder, can only recover 50% of its claim. So that has a similar ish, but not necessarily identical effect to average. And I think the difference between them is that whereas a proportionate remedy is based upon the difference in premium, average is a slightly different concept and is based on the value of the property at risk. And that subtle difference does come into focus a little bit more when I talk about my scenarios that I'll work through shortly. And the second proportionate remedy is that the policyholder can find itself with a policy that's been avoided if the insurer establishes, and it's important to remember that the insurer does bear the burden of proof, if the insurer establishes that it wouldn't have offered insurance at all. But unlike where the breach is deliberate or reckless, where the insurer can keep the premium, if it's merely careless, the insurer must return it. So I'm going to talk now about a number of different examples of where these principles come into play. And it does give rise, I think, to some interesting questions about which remedies insurers can look to in particular situations. So can they apply a proportionate remedy? Alternatively, can they apply average? Or can they do something which seems more extreme altogether and double dip? Can they apply both remedies cumulatively? We'll work through all of that now. So the first example that I'll talk about is declaration-linked cover. So under these types of policies, the policyholder declares at the outset its estimated gross profit for the policy period, and the premium that it pays is then calculated based on that initial estimate, but it is subject to adjustment at the end of the policy period, up or down, depending on what the actual gross profit was. And that type of cover might be more attractive to some businesses than others. So if, for example, you're the type of business that has fluctuating stock levels or variable assets, you might see why this type of policy can be attractive. The way it works is that the insurer's liability is usually limited to 133% of the initial estimate that the policyholder gives. So if that estimate is, let's say, £1 million, when the actual gross profit is £2 million, the insurer is due a top-up premium at the end, and in the event of a claim, its liability would be capped at 1.33 million. Because of the uplift and the end-of-year declaration, average tends not to apply in these types of policies. So let's say in the case of serious underinsurance, the remedy that an insurer has, I think, is based on the initial estimate being a representation of belief or expectation, which I think is the right answer. So essentially what that means is, unless the policyholder has been dishonest, I don't think the insurer gets a remedy here, although it will obviously pay the claim subject to the cap. The second scenario that I'm going to talk about here is what you might call the traditional sum insured route, but which has a condition that the insurer won't apply average. So waiver of average conditions are, I don't think they're standard terms, and the language does tend to vary across the market, but typically they require a survey and evaluation to be carried out by somebody who's RICS registered. The benefit to the policyholder of these types of clauses is that they do give them a certain degree of peace of mind. In the event of a claim, they will receive the full amount of their loss without the insurer applying average to essentially give a haircut. They do eliminate some of the financial risk that you associate with underinsurance, and they are undoubtedly going to be very useful if you're the type of business that might accurately, or rather struggle to accurately estimate the declared sum. But the downside, however, is that they will probably be more expensive, so they will command a higher premium in return. If you have a condition such as this, I think it's very tempting and easy to see why you might think, well, that means that the insurer gets no remedy at all if you underinsure. Because on the face of it, that's exactly what the insurer has indicated is going to happen, or rather isn't going to happen. So the policyholder won't be penalised if they get the number wrong. But I don't think the example is, or rather I don't think it's as simple as that, as this example will hopefully show you. Because even if there is a waiver of average condition, I think the insurer can still have a remedy for a breach of the duty of fair presentation, depending on the facts. Because although the waiver of average clause does remove the insurer's right to proportionally reduce a claim, it doesn't absolve the policyholder of its duty to make a fair presentation altogether. So looking at our fact pattern here, let's say a restaurant insures for £1.5 million in 2024, and the policy has a waiver of average clause. In July 2024, the restaurant is then extended and fitted with some high-end finishes, and it increases the rebuild cost to £2.4 million. And the owner has a has a professional valuation which supports that 2.4 million figure, but doesn't pass that on to its broker or its insurer. And when it renews the following year, it simply reused the old 1.5 million figure, which, as we know, had been superseded. And then let's say there's a major fire which causes a significant loss. And insurers predictably then say that the property was underinsured. In that situation, the underinsurance, as I see it, hasn't been caused by a failure to get the number right. Rather, it's happened because the policyholder has breached its duty of fair presentation because it didn't tell the insurer something that was clearly material and relevant to the risk. So what you have here, I think, is a situation where, notwithstanding the waiver of average clause, the insurer, I think, still has a remedy, which will be determined by whether the breach was deliberate, reckless, or just careless. So what I hope this example shows you is that average and the remedies that insurers have under the Insurance Act can be targeted at very different things, because whereas average deals with inadequate cover that the insured chooses, which is a contractual term, the remedies in the Insurance Act address inadequate disclosure, which affect the risk. So they do perform different things. My third scenario, which I think is probably the most nuanced of the scenarios I work through, is a situation where, again, we're looking at the traditional sum insured, but this time average does apply. So imagine a hotel insures its property for £3 million when the true value is actually closer to £5 million, and there is then a major loss following a fire. On any view, underinsurance by £2 million is serious and extreme. And I think if the insurer can establish that if it wouldn't have written the insurance on any basis, or if the breach of the duty of fair presentation was deliberate or reckless, it would just be entitled to avoid the policy there and then. And logic would suggest that that's the easiest route out of this for the insurer. But let's say the insurer would have still written the policy, but only on different terms. That then gives rise, I think, to a very interesting and complex question as to which remedies it has. So can it apply average or a proportionate remedy, or can it double dip and apply both cumulatively? There is surprisingly very limited commentary which deals with this. And as I said at the outset, this hasn't been tested in the courts yet. But to my mind, double dipping doesn't sound very attractive because a policyholder is effectively being punished twice for the same failure. I think the better analysis, and which I think sounds a lot more commercial, is that the insurer picks one or the other, which may just depend on how this has all happened. So if, let's say, the underinsurance has happened because the policyholder got the number wrong and just chose too low a sum, I think average should apply. If, on the other hand, the insurer can prove that on the facts the insurance was due to, let's say, a misrepresentation, I think it's more likely to then opt for a proportionate remedy instead. In reality, though, I suspect what this will probably boil down to in commercial terms is which remedy turns out to be the more favourable financially. But it is theoretically possible that the insurer can apply both, but in practice I think that's unlikely. And as I said, I think that's unfair and uncommercial. The final scenario that I'll talk about is consumer insurance. I'm cheating a little bit here because this is all about the Insurance Act, but I thought it would be interesting just to cross-compare how things work in the consumer world. So in the UK, average conditions are far less common in standard consumer policies like home or car insurance, and an insurer will generally only have a remedy for a misrepresentation. So the relevant law here, which came before the Insurance Act, is the Consumer Insurance Disclosure and Representations Act, or CIDRA, which imposes a duty to take reasonable care to avoid making a misrepresentation. So in a nutshell, if the consumer was honest and reasonable, there is unlikely to have been a misrep, and so the insurer doesn't have a remedy and must therefore pay a claim in line with the policy's terms and its limits. Where, however, the consumer makes what's called a qualifying misrepresentation to the insurer, which, as with all these things, is generally only discovered once a claim has been made, the insurer then may have a remedy under CIDRA which allows it to retrospectively alter the terms of the policy or avoid it altogether. So much like the Insurance Act, if the consumer's breach was reckless or deliberate, the insurer can avoid the policy and doesn't need to return the premium unless it would be unfair not to. However, on the other hand, if the misrepresentation was merely careless, then the insurer's remedies will turn on what it would have done differently had the misrepresentation not occurred. So using a very simple example here, let's say a consumer, Mr. Smith, obtains a valuation for an expensive painting, and the valuer tells Mr. Smith that it's worth £800,000, but in actual fact it's probably worth closer to £1.2 million, even though there has been underinsurance by 33%. I think our consumer, Mr. Smith, has acted reasonably and has taken reasonable care because he's got a valuation. So I don't think that would be a qualifying misrepresentation. And so as I see it, the insurer would have to pay the claim up to the insured limit. If, on the other hand, let's say Mr. Smith hadn't done anything at all to satisfy himself that the number insured was correct, then you might see why you're leaning more into careless territory, such that the insurer might have a remedy. So I will talk now about the Infinity Reliance case, which I'm sure many of you will know about, but I think it's worth revisiting because it is, I think, a very almost an exam style question on how to do things wrong and where the pitfalls might be. So Infinity Reliance was an online retailer that sold gifts for babies and young children online, and it used a premises in Northampton to excuse me. It used a warehouse in Northampton to store all of its goods. There was a very serious fire at the warehouse, following which Infinity Reliance made a claim under its insurance policy with Aviva for lost sales and relocation costs. The BI's sum insured was based on forecast gross profits of £25 million over a period of 2 years. Unfortunately, however, for the policyholder, that was significantly underestimated because the true figure should have been about £33 million. And predictably, Aviva then applied average to reduce pro rata the indemnity to which Infinity Reliance was entitled, and it did that by reference to the 26% underinsurance. So effectively, Infinity Reliance only recovered 74% of their adjusted loss, which in real terms I think left them about £3 million out of pocket. And they then claimed the shortfall from their broker, Heath Crawford. And their claim was based on a number of points, but essentially they said that they would have been fully insured had the broker given proper advice on A, the calculation of the sum insured, and it said that they provided a document which was misleading in that sense. Secondly, they said that the broker failed to give proper advice on declaration linked cover rather than what I've called the traditional sum insured basis. And finally, they said that the broker failed to give any consideration at all to alternative premises and the additional costs which the broker should have advised upon. The court accepted that at some point during this renewal process, Infinity Reliance actually said to its broker that it didn't want BI cover on a declaration linked basis because it had been hit by I think a pretty high premium adjustment in the past. So moving forward, what it wanted was to have its premiums to be fixed so as to eliminate that risk. Now that was all well and good, and you may be thinking, well, if that's what the policyholder said, why is this the fault of the broker? Well, the broker's undoing, despite the fact that the policyholder expressed a particular preference, was that it didn't explain the potential downside of taking out insurance on that basis. And in particular, it didn't explain the significance or the implications of average. And at trial, both sides experts agreed that a reasonable broker in this position would have recommended declaration linked cover, and that accordingly the broker was in breach of duty. The judgment is well worth a read, and if anybody is particularly keen, do let me know and I'll share it with you, because the judge was rather unsympathetic to the particular broker involved and almost cruel in doing so. But there is one particular passage from the judgment that I think is worth reading to you verbatim, because I do think it ties all of this together quite nicely. So the judge said, "It is not for a broker to force upon its client a type of cover that is unwanted, even if the broker disagrees with that preference, and even if it is a foolish preference. However, the broker must ensure the client understands any disadvantageous consequences, such as the risk that underinsurance would lead to any claim being reduced by average. That would be an important point to hammer home, because it is an aspect of insurance that may not be obvious to the typical client, even an otherwise financially literate one. Even when a preference has been expressed, the reasonable broker should check that it remains a genuine and informed choice at renewal as circumstances change." So the key takeaway, I think, is that differences and the nuances of declaration linked cover and traditional sums insured won't be obvious to a typical client. And even if, as was the case here, your client is particularly sophisticated. And of course, even when a preference is expressed, the reasonable broker should still check that that remains a genuine and informed choice. It's beyond it's beyond the seminar today, but the broker was also in breach of the other duties that the policyholder alleged. So the court found that it didn't provide accurate information on how to calculate the sum insured, and likewise didn't advise the policyholder properly on the alternative costs that would be needed for different premises following a fire or similar. So just to give you some concluding thoughts to wrap up, the key takeaway from all of this is that underinsurance is a massive problem. It's also everywhere, as the statistics that I shared with you at the beginning show, and it does indeed expose policyholders to serious financial difficulties, and can leave them vulnerable when they most need protection, which is usually following a claim. But there are 3 tips that I think I can usefully provide. The first is attack the problem at source. So I mentioned at the start that underinsurance occurs in a number of different ways, and it is an easy trap to walk into. But I think that the theme that's common amongst all of that is a lack of diligence. So it is important, I think, to do impress upon policyholders the need to obtain regular valuations, make sure that they are thinking about and indeed including all the necessary rebuild elements, and also to take account of inflation. And do also, of course, express how important it is to review those figures annually. And one must never assume that the figures and costs that were adequate yesterday will be relevant today. The second is to agree which remedies apply. So as far as my 4 different example scenarios go, I think if you take nothing away, well, the main point to take away, I think, is that insurers can, in theory, apply cumulative remedies for the same failing, even though I think that sounds very unfair and very draconian. So a practical solution is to actually discuss the remedies that might apply at the outset with insurers, and also when they might apply, which should avoid any disagreements in the future that might apply, and also give you certainty as to where each side stands in the event of underinsurance. And finally, I called this client education, but another way to put it, I think, is just to explain the consequences to the policyholder of not insuring adequately, and of course in very plain English. And it does go without saying that policyholders do need to be aware that underinsurance can lead to serious shortfalls, and even for partial losses. And also, as the Infinity Reliance case shows, concepts such as average or declaration linked cover won't be obvious to everybody. So it is important to make sure that your policyholder clients do understand precisely what those terms mean and what the upsides and the downsides are. Because again, as Infinity Reliance shows, this can all go very pear-shaped if that goes wrong. So that deals, or rather that wraps things up. There is time for Q&A, and I will just have a look and see if any of you have asked questions, and I can see that you have, and I'll see if I can provide some answers. Martin Bridges, you've asked where that 76% valuation has come from. That was my research that I've done from a very reliable source. I will happily share that with you after. I'm pretty confident that that figure is accurate, though. George Joplin, could it be due to underwriter and broker negligence too? I think what you're asking, George, is whether underwriters have an obligation to be more engaged and to actually involve themselves in the underwriting. And I think the answer to that is yes, they do, but they are still entitled to accept the information that policyholders provide at face value. And so it's certainly not for an underwriter to do the policyholder's job for it. And George has asked again, the duty of fair presentation, what is the test to distinguish gross negligence, recklessness versus intention? I think what you're asking, George, is where does one draw the line between recklessness and carelessness? The answer is not very clear. There is, I think, a fine line between them. And indeed, sometimes that can be very blurry. I suppose, as I said, that the best guidance I can give is that if you demonstrate a complete lack of care or indifference, which I think is actually quite a hard thing to show by an insurer, that would be more reckless than careless. Careless being just a situation where you've got the number wrong, even if you've done so innocently or naively. And George, you're on a roll here, George. Yeah, you've asked me for the full judgment. Yes, I'll happily share that with you. Can I just confirm that if a client is VAT registered, that is correct to set the sum insured net of the VAT? I think that's right, because the insurer will usually not pay VAT. It is only where you are not VAT registered that I think you would have to properly include in your sum insured an element for VAT. What if an insured has a RICS valuation which insurers consider may be adequate? A second valuation is commissioned and is 30% higher. Both RICS professionals believe that their valuation is correct. Insurers wish to apply average. Will the Insurance Act help? Well, I think your example, Simon, is less about misrepresentation or non-disclosure territory. It's more to do with average as such. So I think it's less of an Insurance Act issue and more of an average one. But one can see that there is an interesting debate to be had there if both RICS professionals disagree on the valuation. And the answer to that, I suspect, is not straightforward and may potentially have to be litigated. You mentioned that insurers get to pick which remedy applies why, with the benefit of the best option not to be given to the insured. That's from David Ash. That's a good question. I think your question, David, touches on one of the issues that, as I said in the webinar, hasn't been litigated or tested in court as far as I know. I suspect it would be uncommercial to apply both. So the question is then, which one do they get? And my gut sense is that they just would probably pick which one works out more favourably to them. But there isn't a clear answer to that, and I suspect that is the sort of thing that will be litigated, and indeed there will be some law on that in due course. Looking at some further questions. How do you approach average regarding a risk with thousands of locations? That's a good question. I don't have a straightforward answer for you. It's one of those situations where I think insurers and brokers need to work together to understand how that might work in practice, and also to understand how average should or shouldn't apply in that situation, because I can see how if you have several locations, then that can become very thorny indeed. David Ash, you've asked again, can the contra proferentum rule not apply here? I'm not sure it can obviously apply here, and I think contra proferentum is sort of the last roll of the dice, I think, if you're a policyholder. I think it's often relied upon very quickly by policyholders, but in real terms, in order to rely on something that's ambiguous, there has to be a genuine ambiguity. So depending on the particular wording of the clause, yes, I can see how there may be some genuine ambiguity, but I think that tends not to be the case in these particular situations. Alan Stevely's asked, assuming there's no deliberate or reckless situation, can the premium average be used as a remedy under the Insurance Act? And if so, in what circumstances? The answer to that, Alan, is yes, I think it can. On a certain set of facts and in a particular situation, I think the proportionate remedy is probably the correct answer. But again, it depends on the particular policy wording. And as I've spoken about, there is an unanswered question, I think, as to whether an insurer can apply one or the other or both. Arseni has asked, has Infinity Reliance been concluded? Yes, it has been concluded. It has been appealed, and I think, to be fair, the judgment was probably unappealable from memory, but I will happily share that judgment with any of you who would like to have it. Apologies if I'm pronouncing your name horribly incorrectly. Amir has asked, is there a limitation on what is a material fact if not defined by an insurer? For example, not disclosing a fact such as financial issues of a client from 20 plus years ago. Yes, there absolutely is. And this is a debate that we readily have with insurers every single day about whether things are material or not. So the classic example is insurers looking to rely upon failures to tell them that you had a director that was involved with an insolvent company 20 years ago. I think the further back in time you go, the less material it's likely to be. Yes, I think there is a limitation argument there in the sense of where one draws the line, but I suppose the answer is not that straightforward. I've seen a question from an anonymous attendee where a client has obtained a valuation which is incorrect. Will insurers rely on it and expect the client to pursue a PI claim against the valuer? I think probably yes, because if an insurer has taken that at face value, as has the policyholder, I suppose, even if it's wrong because the valuer has given the wrong number, and negligently so, yes, it seems to me that there would be what seems to be a relatively straightforward claim against the valuer for negligence. Someone's asked, yes, will the recording be available to watch online? Yes, it will. It will be available under recording, and I will absolutely make sure that the Infinity Reliance is circulated. Finally, someone's asked, some online insurer portals will suggest a higher sum insured if the figure provided is below expectation. Should we be confident with the suggested figure from insurers? Being the risk-averse lawyer that I am, I would say never rely on anybody else. I think it's always the safest course to err on the side of caution and satisfy yourself that the number is correct, rather than relying on something from another. I can see how there may be a dispute to be had, and you may want to put this at the insurer's door if they have suggested a figure. But nevertheless, that's not something I would actively. I wouldn't encourage you to rely on that. I think the safest option and the safest route forward is to always obtain and rely on your own figures. I'll deal with one quick question from Arsani again, which is based on my experience. How often do underinsurance cases require an expert opinion, testimony in court? I suppose it depends on the context. If the question is the property underinsured or not? So I can see how there may well be a dispute between policyholder and insurer. So insurer may say it was underinsured, policyholder may disagree. Yeah, I think you can see how that's a very clear case of where expert opinion would be needed on that issue in order for the court to decide which side is correct. Okay, I'm going to wrap up there, but I'd like to thank you all for listening in. I hope you found that an informative and useful session. And as I said, the recording will be made available to everybody after the session. So thank you for listening in. And apologies if I haven't had the chance to deal with every one of your questions. Please feel free to get in touch with me and have a chat about this, and I'd be all too happy to do that. Thank you very much and have a good day.